What is the purpose of a living trust? To avoid probate. What must a settlor is the person that created a trust, do prior to death? They must retitle the assets into the name of the trust. What happens to those assets that are not in the trust when the settlor dies? Hello again, this is Certified Probate Real Estate Specialist Daryl Williams with Win-Win Realtors here in Southern California. If you are new here and you like our content, be sure to like, share, and subscribe. Let's get started. When a person passes away with assets still in their name, those particular assets are called their probate estate, or is part of what's called their probate estate. Probate assets. Those particular assets will need to go through a probate proceeding in order to transfer the ownership of those assets, which means more delays, more cost, and less privacy, since a probate is a public proceeding. Good for us that the law recognizes that we human beings are fallible, and we often accidentally or through neglect inadvertently leave our assets out of our trust. So there are things that we could do to still avoid a full-blown probate proceeding with particular assets that were accidentally left out of the trust. One of these solutions is called a pour-over will. A pour-over will encompasses all assets that were left out of a trust when the settlor dies. However, there is some form of a probate in this case. Another option to fix this problem is called a Heggstad petition. Often, when settlors refinance their property, the lender will require them to take the title out of the trust. Once the property is refinanced, the settlor sometimes forget to put the property back into the trust. If that occurs, when the settlor passes away, the settlor's representative can petition the court for a Heggstad petition, allowing the petitioner to put the house back into the trust and close that trust administration based on the instructions of that trust. Another option I'm familiar with, but I'm not sure if it's the last option, is called California's small estate affidavit. If those assets that are outside of the trust are less than today's value, $184,500, then a petitioner can file a small estate affidavit in order to transfer the title to those assets. Question of the day: do you know someone who had a living trust, however, when they passed away, they had assets that were not within the living trust? What happened? How did they resolve that issue? Let us know in the comments below. What is the simplified way to avoid problems such as the ones we talked about? Keep your living trust updated. Every time there is an event that takes place in your life, a new baby, a new house, a new wife, keep your living trust updated and keep your beneficiary designations updated. I'm Daryl Williams. This is Win-Win Realtors TV. If you know someone who's dealing with a probate administration, a trust administration, share this video with them. They may have questions in reference to the trust real estate or the probate real estate. Thanks for watching. This video has been for information purposes only. It is not legal advice. I am not an attorney. If you need an attorney, please contact one. If you need an estate planning or a probate attorney here in the Los Angeles County area or Orange County area, feel free to reach out to me for a referral.